Good afternoon. My name is Bob Henderson. We'd like to thank you for attending our webinar this afternoon. And want to tell you that if you have any questions, all you need to do is click the middle green chat icon at the top of your page. Then you go down to the bottom of the page and select Host at the left-hand side bottom. Type in your message and send your question. What you'll learn today is, first of all, unfortunately, there's bad news. But there's also good news. And there's a huge opportunity. And we're going to tell you how to capitalize on it. And then we're going to give you the nitty-gritty on how to do that. So today you'll be hearing from, first of all, me, Bob Henderson. I happen to be a fellow of the American College of Trial Lawyers, and I'm a principal of RJH Consulting. We work with small law firms on operations issues, and I'm also a co-founder of the Elder Law College. Also will be Scott Solkoff. Scott is a board-certified elder law attorney, and he's also the principal of Solkoff Legal in Delray Beach, Florida, and also a co-founder of the Elder Law College. And Jan Friedlund, also a principal in RJH Consulting, and a co-founder of the Elder Law College. So, first, the bad news. In general, the outlook for today's law school graduates couldn't be more dismal. Why is this? Why have things changed? There are many reasons, and some are the 2008 recession has changed the practice of law forever. Clients seek lawyers less, and they're more resistant to paying legal bills. Jobs that once required lawyers for sifting through documents before a trial, for example, are increasingly being automated. Others are performing services customarily performed by lawyers, such as CPAs. Do-it-yourself services like LegalZoom are gaining popularity with consumers. Basic legal work is being outsourced to countries like India and the Philippines. But now for the good news. All is not lost. There still are growth areas in the practice of law, and elder law is one of them, and it presents a huge opportunity if you get in right now. The changing population has created a growing niche for lawyers who provide critically needed services to the elderly and their families. The baby boomer population is just beginning to reach retirement age, and that market will continue to grow. The population of Americans over age 57, for example, is projected to increase to 100 million during the next 2 decades. This new democracy will present novel challenges to traditional political, societal, medical, and especially legal establishments. For the legal profession, however, elder law presents a huge, ever-growing opportunity for those who have the imagination and the vision to capitalize on it. We hope that is you. Today's reality is that the wealth of the nation is concentrated in its 57 to 75-year-old population, and people are living longer. After age 67, government figures show that 7 in 10 Americans will need long-term care from some source, including nursing homes. Depending on where a person lives, the median bill for a private room in a nursing home today is $91,250. Elder law practice is profitable. You're not representing the little old lady on Medicaid. It involves people with real means who can afford to pay for the protection they need that an elder law practitioner like you can provide. Elder law also can be a significant feeder for virtually every other area of law practice. For example, by providing sage legal advice for a client's aging mother or father facing a crisis of aging, you will earn that client's everlasting loyalty for whatever other legal needs they may have. Contrary to many other areas of practice with which you may be familiar or in which you may engage, elder law practice is not confrontational. By practicing elder law, you will not only be providing a needed service, but you will be emotionally and spiritually rewarded in helping people who really need your service. So now I'm going to turn over the program to our partner, Scott Solkoff, and he will give you an overview on how to become involved in an elder law practice. Scott?
Hi, everybody. Glad you're here. Thanks for joining us today. I'm going to get right to it. So, what is elder law? First of all, I would distinguish it from estate planning by understanding that an estate planning attorney is focusing on what happens after death and then doing some work with powers of attorney and advance directives, whereas the elder law attorney is focusing on the lifetime needs of our clients, typically the elderly. But the reason why we're increasingly calling our practice a special needs and elder law practice is because the same problems that are faced by the infirm elderly are also faced by people with disabilities of all ages. And so as we talk through matters today, you'll see that age and the term elder law is somewhat of a misnomer. I understand the transition to elder law because I did it myself. My first job out of law school, I took the highest paying job I could get. I lost my moral compass. I forgot why I went to law school. And I was paid a lot of money and had a really sweet office. But I hated what I did. It was very stressful work. I saw the lawyers that had been there for 2 or 3 years ahead of me, the billable hour pressure, the fact that they didn't see their families very much. And I had one human being client the entire time I was there. So I resolved to do something more meaningful. Fortunately, I had a father in the business. He started elder law when there was no elder law organizations, started very early, wrote one of the first books in elder law, and helped to found the organizations. I didn't think I wanted to do that work. But I sat in his office one day and watched as family after family came in, and he helped them with the most core human issues you could broach as a lawyer. It was extremely meaningful to me. I couldn't believe the way he was able to help those people and get paid for it. So I quit my job, I took a big pay cut, and I learned how to be an elder law attorney. And over time, I learned the business of elder law. I learned how to make it financially viable so that I could do it and raise a family. So I want to share with you today an overview of the practice and how to go about if you're interested in becoming an elder law attorney, interested in transitioning into this field or developing an elder law department in your firm, how you can go about it quickly and efficiently while still being able to make money in the meantime so that you can finance your life while you're learning elder law. So, and I understand that not everybody has a father in the business, mind you. That's why I'm doing this. So, first off, trying to learn elder law or any practice area from books or seminars or from larger organizations is very, very difficult, not enough. Most people, if you take a foreign language in college, you can't learn very well a foreign language without immersion. And same too with a practice area in elder law. It's very difficult to learn a field of practice by reading it in a book or attending a seminar or even shadowing somebody in their office. A true apprenticeship is the way lawyers used to learn how to practice law, and still should, in my opinion. And so that's the way I learned. It's the way I have taught other lawyers since then, and it's really what we're talking about today. I'd say that there are 3 requirements for success in elder law. One is understanding readiness versus expertness. Well, 3 requirements that I'll cover with you. Also, readiness versus expertness, understanding that you can open up your practice and start your elder law practice before you're an expert. Often we let the perfect be the enemy of the good. But we can make it work well and have your expert in the background so that things get done the right way. Then there's practical and substantive knowledge. There's the learning how to do the law. There's learning about the toolbox, and then there's learning how to practice that law, how to work it in your firm. And you may be doing another practice area. In fact, I know that there are all different practice areas represented on the call today, about 120 of you. And running an elder law practice is going to be similar. It's a law practice, going to be similar to your family law practice or your civil litigation practice or your criminal law practice in some sense. But in another sense, it's an elder law practice, and you're dealing with elderly clients and their families, and you're going to have a different workflow. Elder Law College is about developing that apprenticeship model so that you learn the substantive practice areas and how to do it in your office efficiently without taking years of trial and error. The objective, therefore, is to transition to a rewarding special needs and elder law practice as quickly as possible while gaining expert class knowledge, earning an income through the transition, and feeling confident with clients right away. 3 requirements for success. Substantive knowledge. You want to be able to learn the practice areas and the necessary tools. Understanding, for example, the difference between a power of attorney that you may have used before in your estate planning practice and a power of attorney that you're drafting specifically for your elder law clients. So there's that substantive knowledge of knowing what provisions need to be added to that document. And then there's also the ability to convey that to the client so that the client understands the value that you're bringing them, that the power of attorney that they came with is perfectly fine and right, and may have, by the way, have been drafted by the attorney who referred them to you, and it was fine and right for that purpose, but you're doing it now for another purpose, and you'll be able to show that to them. It distinguishes what you're doing and folds into your practice. Then there's the practical knowledge. How do you run your practice? Job descriptions, workflows. If you've been practicing law for any length of time, you know about this in some sense and have to transition that and understand how to apply it in an elder law practice. Once a plan is implemented for a client, for example, just an example of workflow here, we have checklists and workflow protocol for the transition of that file to what we would call application mode. So, for example, if we have a client where we're doing public benefits planning, we're sheltering assets and getting everything ready, there's a lot of law work that the lawyers are running. But then also we have what we call public assistance coordinators ready to handle the application. Well, in your office, having the checklists to make sure that everything is set and that the lawyer has green-lighted the application to be filed and that there's accountability. What happens if the application is not filed? How does the lawyer know that it was not filed, or how does the lawyer know it's filed? Not filing that application can be a very costly mistake if it's not done timely. So you have to have the systems for that, just by way of example. Practical knowledge would also involve pricing, time management, money-saving lessons, etc. Then there's having your expert on call, the third requirement for success. It's like the 80-20 rule. You're going to be able to handle with a crash course and with full immersion quickly, you'll be able to handle 80% of all the cases. And then 20% of those problems will present that are a little beyond your knowledge. You know that there's more to it than what you're able to bring to the table at that point because you're new. So you have your expert on call, and you still get the right thing done for the client. And that's, I think, critical as you're starting off into a new practice area. I still have mentors myself. It changes over time. Then there's the readiness versus expertness, and understanding again that we don't want to let the perfect be the enemy of the good. The number two objection to starting a new practice is I can't do this if I'm not going to do it right. I've got to learn how to do it, and it's going to take me too long. So how do I start taking cases and be able to earn income while I still don't know everything? Well, the answer is you have to know it enough. You have to know that 80%, the primary tools, which I'm going to cover with you, and you have your expert on call. You have to let that happen. The number one objection, money. I'll get to that. There's a shortcut to one's expertise, but no instant solution. You could spend years going to seminars. A college-style immersion in a professional apprenticeship is the shortcut and solution. I go to many seminars, and I learn quite a bit, but I could never really take that back and apply it in my practice with confidence without a guide, at least at the beginning. We want to be ready and capable and feel comfortable with our knowledge so that we're quickly, with our experts in the wings, able to handle cases so that you become ready of mastering the basics, the level one issues. And you do that through, again, intensive immersion, a cram course, just like with a language. You can't learn it. I took Spanish for 4 years in high school, and all I can say is, "Está Susana en la casa?" That was my lesson one. Very little Spanish that I can speak. But if I immersed myself in Spanish, if I was only speaking Spanish, even if I did that for a short period of time, I'd come out better. That's what I have a friend in the CIA. That's how he learned his language. And it's no different with a practice area like elder law. It takes a cram course, intensive immersion, and then you go from there. So you have an expert in the wings to deal with the 20% of that 80-20 rule, and you're going to have the confidence then to sit in front of the client and inspire confidence in the client because you know what you're doing. You feel that you know enough, and you're confident because you have your expert in the wings, so that you're conveying that confidence, and people see that and feel that, as well as your referral sources and even your staff knowing and understanding that you have the confidence to represent your clients, and they have that confidence in you. Substantive knowledge, I will break into two categories today. First stage practice area categories, which are the essentials. You can't open your door without it. And then second stage practice area categories that you'll learn over time, that your expert in the wings will be there ready for you when you need it, but those second stage practice areas you learn over time. It would be very difficult, or if not impossible, to learn all of the essentials, the first stage practice area categories, and then drilling down to the second stage practice area categories all before you open your doors. And yet you still have to confidently and expertly represent that client. So substantive knowledge starts off with, in a special needs and elder law practice, incapacity planning and solutions. And I would define this as addressing these lifetime needs of our elderly and disabled clients through the use of specialized tools. For example, our powers of attorney look nothing like a traditional estate planning power of attorney. Yours won't either once you learn why. Our advanced healthcare directives are distinguishable as well, and our lifetime trust planning. So a power of attorney, for example, just to give you a sense of what I mean, we want to have specific and specialized planning authorization available for the attorney. In fact, because the government will require that specificity. We want to waive self-dealing in some instances, but still do it in a controlled manner. So our powers of attorney ultimately, with these elder law, special needs specific provisions, end up being quite necessary in our practice and distinguishable from what the client may already have. post-mortem estate planning. Well, if you've done estate planning before, you know wills and you probably know trusts. And wills and trusts form a very big part of what we do, but we may use them differently, and we don't start with that. We're starting instead with our lifetime planning, and that informs the postmortem estate planning, and it is a very different outcome because of that. An example of that would be if I'm doing asset protection planning in a long-term care context, and the well spouse dies before the spouse who is receiving public benefits. Now that spouse that's receiving public benefits, the survivor, would inherit money, and even if they're not provided for, we've got elective share statutes that come into play. How do we deal with that? So that's an example of postmortem estate planning specific, to elder law issues. And we have lifetime planning for long-term care. And look, the bottom line here is that a very big part of an elder law practice, one of the things that distinguishes the elder law attorney, and I'll tell you my biggest source of income and practice focus, is how do my clients avoid impoverishment at the cost of long-term care. It is such a big deal. We have right now a lunch and learn going on in the other room from an area geriatric care manager explaining to my staff the current costs in our area of long-term care. Look, most people can't afford $100,000 a year for care. In my neck of the woods, a nursing home costs $8,000 to $12,000 a month. So by doing our work, we're able to take countable assets and render them non-countable in ways where we can, of course, show the government everything that we're doing and explain to the client, and that value is so manifest that your fee is not the issue. You can get paid well for doing it, and you're bringing an incredible value to the client. Also, as part of substantive practice area under lifetime planning for long-term care, by that category, I also mean understanding Medicaid, VA as need-based programs, and understanding entitlement programs like Medicare Basics, the Medicare rehab benefit after a person leaves the hospital and gets care in a nursing home, Social Security basics, and the like. All of that would be our substantive first stage practice areas. Then we go to our second stage practice area categories. And this is where we drill down farther and with practice area categories that you do not have to master in order to open your doors. These you have to master before you can open your doors and start taking elder law cases. But you can do that through an intense training that we can talk about, and then you're there. This is your second stage practice area categories where you drill down farther and learn later, or your expert in the wings has that knowledge. So we start with estate and trust administration. This is not much different than traditional estate and trust administration in a typical estate planning practice, but there are some significant differences because, for example, if we're working with public benefits, we have to fold that in to Medicaid estate recovery issues and the like. With estate and trust administration, we're also, next to that, we're talking about guardianship, conservatorship. This is if we can't help our clients avoid guardianship through the use of self-delegating their rights through powers of attorney, advance directives, or trusts, we go to guardianship or conservatorship. You don't have to start taking those cases at the beginning. You'll probably want to as your practice develops. Special needs trusts. Special needs trusts form a part of first stage when we're talking about lifetime care planning. But drilling down further with special needs trust allows us to do such work as settlement protection planning and work beyond just planning for a disabled heir, which is a stage one issue. Facility resident rights, this should read instead of facility resident trusts. I just had a client come in last week, a wonderful man who's caregiving for his wife. He's been caregiving for her now actively for 5 years. She has, her Parkinson's now is very advanced. And she's in the facility, and he came to me 3 days before she was about to be discharged. And he's trembling, and he's scared, and he can't deal with all of the other things that are going to need to be done until his immediate crisis is dealt with. And so it was for me to tell him, when he kept on saying, she's going to be discharged in 3 days, for me to say, no, she's not, and here's why. And but how am I going to deal with that? I'll deal with that. We'll take care of that for you. And calming him down and letting him leave the office free of those concerns, and actually then being able to help his wife and him with all of their other issues. So resident rights, understanding those rights, I would call that a second stage practice area category. Your expert in the wings will know it while you're in first stage, but it's something that you're going to want to learn and even master later on. Dealing with insurance and health plans. This is, again, second stage. You'll know some of it for first stage, but you want to be able to talk about Medicare and private health insurance, long-term care insurance, being able to talk about coordination of benefits and how they all fit together. Your clients may have long-term care insurance, but that long-term care insurance may not be enough to pay for the nursing home bill, usually isn't. So how do we use both and get all that together? So then there's your practical knowledge. So you have your substantive, what is the law stuff, and then your practical knowledge. And what I'm getting at here throughout is you're creating a plan for building up your knowledge and your practice. You're outlining what you need to do in order to get there. Your substantive knowledge areas, checking them off as you go, and then your practical knowledge, creating a well-oiled machine so that your office works for you instead of you working for your office. You may have heard the term working in your practice and then working on your practice. Obviously, we need to do both. So there's getting the phone to ring. Every one of us has to do that as a lawyer. We need to be able to cultivate business. But of course, in elder and special needs planning, there's a different market to understand. And for me, in my success, it was really cultivating an annuitized referral source pool, so that I had the distinguished, I would say there's wholesale marketing and retail marketing. Wholesale marketing, I don't mean Costco. I mean being able to get to the social workers and the other lawyers and identifying those people that are going to have repeat referrals for me, do a great job on the cases so that they want to continue to send me that work. And that's cultivating my referral sources, and then also identifying how to reach the retail market, the senior citizens themselves, and I would also add their adult children. Then there's getting the phones to keep ringing, representing success with successful representations. You need your referral source to know you did a good job. You need the client to know you did a good job. And so there's ways of doing that. There's running a successful special needs and elder law practice for yourself. And that's understanding how you price your services so that you're making money and doing a good job, balancing, being able to not charge too much. You want to be able to help people, but charging enough where you make what you need to earn and you're paying your staff well. Phone calls and intake procedures are critical. Phone calls, intake, and calendar are the biggest issues to running a successful practice. What info is gathered before and at the meeting? You all have to deal with this in your current practices, but it's going to be completely different, of course, in an elder law and special needs practice. And so we have documents that we use in my office, forms, checklists that help us with that, and our workflow processes. Having your expert on call means having your apprenticeship remaining supreme. Your apprenticeship remains the only method of mastering an existing discipline. In my opinion, you cannot learn it from a book. I write a book. You're not going to learn it from the book. You need the book and somebody to apprentice, a mentor, but an active mentor. I'm talking about a mentor that has your interests at heart, who's not competing with you, where you're an apprentice and you have your mentor and you're both working towards a common good, and your mentor is even accountable to you. Practicality dictates that you get up and running quickly. It's you don't have 3 years of apprenticeship or 4 years of apprenticeship like in the old days before law schools became necessary. You have a short amount of time. And I know that it can be done in a short amount of time because I've done it for lawyers. I've trained lawyers with 3-day crash courses. It's like a boot camp where a lot of information is shared. But by the end of that 3-day period, We've got all of stage 1 practical knowledge, substantive knowledge mastered, and the practical knowledge to be up and running. You want to feel secure. You want to know that you've got your on-call experts to get you through anything that you don't already have the knowledge for. And you want to be able to keep those on-call experts and cultivate new ones. In about 3 weeks, I'm going up to Virginia for a meeting with just 8 other lawyers. We get together from time to time, and these are lawyers who I look up to as far above me, who I get the privilege of talking to, and we all share information, and they'll ask me questions, and I'll ask them questions. And so your mentorship changes, of course, over time. You'll still want mentors, but it'll be more of you sharing information as well. So I'm going to turn it over now to my partners to talk about how we transition.
Hi. After you have learned in the last hour, you will agree that yes, transitioning is absolutely achievable with the right knowledge and tools, which is why Scott, Bob, and I founded the Elder Law College. The college includes that immersion training that Scott referred to, an intensive 3-day training program, as well as membership and support during the transition and continuing throughout your practice. The intensive 3-day training covers the substance of the law, how to market your practice, how to price your services, how to manage cases, and advice on transitioning your practice. While this is certainly not Scott's first time teaching this curriculum, it is the first one in this setting, so we are offering a discounted tuition in order to get your feedback. The tuition is $1,800 for the whole 3-day program and $150 a month for a 12-month membership, or a total of $3,600, which we are sure you will recoup with your first client. The course has already been approved for CLE accreditation in the 12 states in our initial target area. Take a look at our website for details. Membership benefits also include online tutorials on demand, the complete library of proprietary documents and relevant updates, all of Scott's past publications and presentations, and there are many, and any new articles you'll get hot off the press. A listserv to take advantage of the expertise of others, and other features that you, as a member, may be a part of developing. The program is scheduled for November 19th through the 22nd at the beautiful Gaylord Palms in Orlando. As Bob said at the beginning, there's an exponentially growing need, and this is the time to establish yourself in this practice area. Please also be aware that, as Scott said, there are more than 120 participants on this call, and we had as many in the previous seminar, and the class size is limited to 15 students. That's because we want to assure the highest quality learning experience. So if you are interested or have further questions about the program in Orlando, simply chat your name to us, and we will follow up. Thanks. I'm going to turn the seminar now back to Scott to answer as many of the questions you submitted during the webinar as time permits. Thanks.
And I would encourage you, I've got some questions that I'm going to answer that are probably going to provide answers to you if you didn't ask the questions. And in addition to that, I'm going to be able to take new questions from you. So you can press the talk bubble, send me a message, and I'll try and answer your question. We have time. So one question, and I'm asked this question quite often: how can you earn fees from people who can qualify for Medicaid? Well, the reason why they're coming to you is because they have assets, but not enough. They don't have enough. They're not millionaires, generally. These are working class people who have maybe between 50,000 and 700,000 on average. And at the cost of care, they're not going to be able to sustain it. So you're helping them with that, and they can certainly afford your fees. Second question. Okay. How can people wait out a 3-year look-back period? That's how I'll summarize the question to. First of all, it's a 5-year look-back period. If you're not familiar with look-back periods, the government takes the position, and this is a federal law, that if we're doing Medicaid planning for a client, that any gifts made by that client will be added up over the 5-year period preceding the Medicaid application. And then a penalty is assessed. They take Medicaid away from that person. And the formula for assessing that penalty differs from state to state and sometimes within each state. But it's a big penalty. And so most of the time, we're actually doing planning that is not a gift. It doesn't meet the government's definition of a gift, and therefore is not subject to the 5-year look-back period. So that when a client comes to you in crisis, as they often will, you'll be able to help them in days instead of months or years, so that you can get an application filed quickly, because every month they're not qualified could cost that client another $5,000 to $10,000 to $15,000. So again, the value you're bringing to that client is manifest. Sometimes we do purposely subject our clients to a 5-year look-back period after understanding all the pros and cons. Next, how do elder law attorneys charge? Well, all different ways. Attorneys throughout the country have different ways of charging. Some charge hourly. Few do, though. Most charge by a flat fee. And then there's different ways of calculating that flat fee. Some will do the interview at their office and decide based on what they think that client is going to take. They'll quote a fee and they'll stick to that fee. And they'll do a representation agreement based on that. Some charge a percentage of the assets. For example, here in Florida, our state statutes for estate administration, probate, recommend a reasonable fee for probate. It comes out to about 3% of the assets. Some elder law attorneys use that as a guide, suggesting to the client that they're bringing more value than a probate. And other folks have a set fee schedule based on documents and what they're doing. So I can share with you, the different ways that we work with our clients. It would take too long for this call, but we are almost always working on a flat fee. Very rarely do we charge hourly for long-term care planning. For guardianship and resident rights advocacy and some other issues, we have to charge hourly. How can Medicaid planning be ethical when you are helping wealthy people to get need-based public benefits? Okay. I understand the question, and it's a legitimate one. But we're not helping wealthy people get need-based benefits. My clients that are coming to me are generally not millionaires. I'll tell you some exceptions and why I still think it's right in some exceptions. But there are people that have money that don't have enough to finance care. Very few people could have enough saved at retirement to finance $8,000, $9,000, $10,000 a month in a nursing home or for home care, which can be as expensive. So by being able to help those folks take those hard-earned assets and be able to set them aside, what we're doing, we're not doing it to preserve an inheritance. We're doing it because if we didn't, they'd have to spend down all that money, meet your state's Medicaid poverty limits, then go on Medicaid, but have nothing or very little left to pay for everything the government doesn't cover. And the tragic circumstances that we see caused by that tend to not only changes in quality of life, but without exaggeration, sometimes life and death money buys care. So you're able to do it. You're able to help folks. If this was your parents, you'd certainly want to take advantage of everything you could do legally and ethically to help them, and that's why we do what we do, and I have no regrets. I love what I do, and it's all on the open. We never do anything that we wouldn't feel comfortable publishing in the newspaper. My mom always said, whatever you say, make sure that you say it in a way that if they put it in the headlines, you won't be embarrassed. I try to live by that, and I try to live by that in my practice as well. What should I expect in terms of income? That's a tough question to answer. Of course, it differs greatly. It differs greatly from practice to practice. I would say that I don't know any lawyers who do what I do, or who have similar practices, have elder law and special needs practice, who are making less than $150,000. I know lawyers that are I'd say average are between 300, probably, well, maybe between 250 and 500,000 from what I have seen. I have I know of attorneys that are making well over 1.3, 1.4 million, and that's net income. The practices themselves are going to vary greatly based on your geography and how big you want to be. And that's one of the things that I like talking to my quote-unquote students about, my apprentices. How big do you want to be? You don't necessarily want to be the biggest. Do you want to manage all of that? And in order to make more money, to be on the upper end of the spectrum, you're going to have a bigger practice. And so I can tell you how that works and the decisions that you'll have to make as we talk more. I'm going to read through some of these other questions. Okay. I am interested. Okay, these are people interested in finding out more, signing up. Do the expert state-specific knowledge? Okay, so Medicaid is a state and a federal program. There are state rules and laws and federal rules and laws. Medicaid is going to form a very important part of your practice. And so you will have to know your state system. No, I don't know all 50 states, and I certainly can't keep on top of all the changes in all 50 states. Keeping on top of mine is enough. But I have been able to teach lawyers all over the country, and been able to do it because, first of all, there are more similarities than differences. And the way Medicaid law works is the federal government lays the framework and sets certain minimum standards that must be met. A state is not able, legally, to make rules that are more restrictive than what the federal government creates. And so we'll go through all of that, and I can tell you exactly how you access the state materials, and I can even show you how to do that. And that's how it works. When I've had clients from other states, apprentices, we actually sit down, and I have already gathered some information, but that does take a little bit more. VA benefits are all federal. Estate planning, trusts are based on the common law. Wills, what most states follow the Uniform Probate Code, which I'm well familiar with. And even if your state doesn't, we're able to do everything that you need to do with wills and trusts. I would be able to help you with. And so our model is an apprenticeship. I am the teacher, and on the substantive practice areas. And then we were also privileged to have Bob and Jan, RJH Consulting, to share with you personally. I accessed Bob and Jan well over a decade ago to help me with my practice. I've hired advisors and mentors, and Bob is one of the busiest consultants to small law firms in the country. So you have that too. There's not a team of lawyers in Elder Law College. The idea here is to have a one-on-one, to have somebody that's accountable to you, who has a system that's been proven and developed to allow you to be up and running quickly. And that's what it's about. I mean, this seminar today is, yes, we want you to participate. in our model. We believe in it, and I believe in the practice area. I love what I do, and it's a tremendous privilege to be doing what I do. I think you'll like it too. So in some ways, we're here to tell you how great we are and what a great concept this is. We're very excited about it. We've done it on a small scale before. This is the first time that I'd be doing a group together. And that's why the pricing of this is a fraction of what I charge when I'm doing a one-on-one in somebody's office. So we're confident that this will work for you. We're confident that you'll be able to be up and running quickly on your stage 1, and then you'll have your expert in the wing for your stage 2. I remain available to you as an expert, and I will also be able to refer you to experts in your state. I have another question. There are already over 6, okay, this is from a Florida lawyer. There are already over 6 Florida certified elder lawyers in my community of around 350,000. Is there room in this community for more? I don't know your community. I can't tell you specifically. I can tell you that, I'm in Florida, and in my area there are probably about that many certified specialists, and then another 30 or 40 maybe other elder law attorneys that do it in varying degrees. Okay? I can tell you without a doubt that there is plenty of room in the market, and even in my space where we have 6 certified elder law attorneys or so in my area, I would say that we need more good, ethical elder law attorneys who focus on this as their primary practice areas. Most lawyers that hold themselves out to be practicing elder law are not full-time at it. For example, there are 1,800 members of the Florida Bar's Elder Law Section, but I'd say comfortably that only about 350 or so are doing it all the time. Now, Florida is a very big state. There's room for probably many times that amount. And I think this is the beginning of the field of elder law. Elder law is still a very new practice area. And as the baby boomers come of age, I don't think there's going to be enough elder law attorneys. So that would be my take on it. Another question is, do you have to be a certified? It says, I'm interested in learning more. Do you need to be certified? And if so, what does it entail to obtain certification? Certification is not even available in every state. Florida, my state, happens to have certification, as do most other states. Certification is offered by your bar, and in most states, it's going to involve a test, kind of like a mini bar exam. It's no fun. It's a full day. You have to study. Second, they do peer review, so the judges and lawyers in your area are going to check you out, and they're going to fill out paperwork from the bar that they get confidentially that you never get to look at. Then there's an audit of your practice, at least in Florida, where they're making sure that you've had enough of each part of your elder law practice. So the answer is you do not have to be certified to be an elder law attorney. You won't be, because in most states there's a minimum practice requirement. In Florida it's 5 years, 5 years of elder law. And so that's what you work towards. In my opinion, getting board certified is very valuable. But I was doing plenty of business and without my certification. NALA, the National Academy of Elder Law Attorneys, also offers through the National Elder Law Foundation a certification program as well. But most states have a very meaningful state bar certification process. So I hope that answers that question. Let's see. Pricing issues, I'm going to have to defer to Bob and Jan on that. And what I would suggest is if you have questions about how Elder Law College charges and all of that, put your email address with your question and let Bob and Jan explain anything to you. We don't want money to be an obstacle. We've tried to price it very moderately. The only reason why, you can imagine if you were to take off all of this time and develop it and then provide it, it would cost you a lot more than $1,800. And so the only reason we're able to do this is because we're doing a small group. And so if this is for you, if you'd like to learn more, we believe that this is the way to do it. So thank you very much for participating today. And if you're interested in Elder Law College, please contact us for more information.